The certified letter arrived on a Tuesday morning, and I knew before opening it that my life was about to get complicated in ways I never imagined. When I bought this beautiful Victorian house in Asheville, North Carolina 3 years ago. My name is Henry Quinlan, and I'm a restoration architect who specializes in historic buildings. When I found this 1887 Queen Anne Victorian on the market, it was love at first sight despite its terrible condition. The place had been neglected for decades, with a leaking asphalt roof that had rotted half the attic rafters, peeling paint, and foundation issues that would make most buyers run screaming. But I saw its bones, its potential, and most importantly, I saw the original copper standing seam roof underneath all those layers of cheap asphalt shingles that various owners had slapped on over the years. I spent 18 months meticulously restoring the house to its former glory, working nights and weekends when I wasn't at my day job. I documented everything, pulled every permit, and worked with the North Carolina Historic Preservation Office to ensure everything met their strict standards. The crowning achievement was restoring that metal roof to its original magnificence, stripping away the layers of modern garbage to reveal the beautiful copper patina underneath. Where sections were too damaged, I had custom copper panels fabricated to match the original 1887 specifications exactly. The house sat just outside the official historic district boundary, in a neighborhood that had been slowly gentrifying over the past decade. 5 years ago, some enterprising developers had bought up several properties, built some cookie-cutter McMansions, and convinced enough homeowners to form a homeowners association. I had specifically asked about HOA restrictions before buying, and the previous owner assured me the house wasn't part of any HOA. The property predated the HOA by over a century, and the HOA covenants had been created without any claim to my lot. That certified letter proved someone disagreed with that assessment. I tore open the envelope and read the formal notice with growing disbelief. The Asheville Heights Homeowners Association, represented by their president Patricia Carmichael, was demanding I remove my unapproved metal roof and replace it with appropriate architectural shingles that match the neighborhood aesthetic within 30 days. Failure to comply would result in fines of $500 per day. They claimed my property had been involuntarily incorporated into the HOA boundaries through some obscure legal mechanism I had never heard of. I read the letter 3 times, my coffee getting cold on the kitchen counter. This had to be a joke. My metal roof was the original roof, restored at enormous expense and approved by the State Historic Preservation Office. It was literally older than their entire HOA by 118 years. I pulled out my phone and called my real estate attorney, Marcus Webb, who had handled my property purchase. He listened to me read the letter, and I could hear him typing in the background. "Henry, this is completely absurd," he said. "Your property deed makes no mention of any HOA covenants, conditions, or restrictions. You can't just involuntarily incorporate someone's property into an HOA, especially not retroactively. That's not how property law works. So what do I do?" I asked, staring out my kitchen window at the manicured lawn across the street where a woman was setting up campaign signs for some local election. First, don't panic. Second, write a formal response denying their claim and citing that your property is not part of their HOA. Third, send me everything you have about your roof restoration. If they push this, we'll bury them in documentation. I thanked Marcus and hung up, but I couldn't shake the uneasy feeling in my gut. I had dealt with enough bureaucracy in my career to know that sometimes the person with the most paperwork wins, regardless of who's actually right. That evening, I drove to the address listed on the HOA letter for their monthly meeting. The Asheville Heights Community Center was a bland, beige building that looked like it had been designed by someone who had only ever seen buildings in catalog photographs. Inside, about 20 people sat in folding chairs facing a table where 3 board members held court. Patricia Carmichael sat in the middle, a woman in her late 40s with an aggressive blonde bob and the kind of expression that suggested she had been demanding to speak to managers since birth. I slipped into a seat in the back and listened as they discussed various neighborhood matters. Someone's garbage cans were visible from the street. Someone else had planted unapproved flowers. A family with teenagers was accused of playing music too loud on a Saturday afternoon. Patricia wielded her gavel like a weapon, her voice dripping with condescension as she addressed each violation with the gravity of war crimes. Finally, they reached new business, and Patricia's eyes scanned the room until they landed on me. "Ah, Mr. Quinlan," she said, pronouncing my name like it was something distasteful. "How generous of you to join us. I assume you received our notice regarding your roof violation." I stood up, keeping my voice level. "I did receive a letter, yes, but I'm confused about several things. First, my property isn't part of this HOA. Second, my roof isn't a violation of anything. It's a historically accurate restoration of the original 1887 copper roof, approved by the State Historic Preservation Office." A murmur went through the small crowd. Patricia's smile didn't reach her eyes. "Mr. Quinlan, when the HOA expanded our boundaries last year to include several adjacent properties, your parcel was included in that expansion. You should have received notification." "I received no such notification, and you can't just unilaterally decide to include someone's property in an HOA," I said, feeling my temper starting to rise. "That's not legal." "We have legal counsel who assures us otherwise," Patricia said smoothly. "Regardless, the fact remains that your metal roof is an eyesore that negatively impacts property values. Our architectural standards require traditional shingle roofs in earth tones. Your roof is green and reflective and completely inappropriate." "My roof is copper with a natural patina," I said, my voice harder now. "It's green because that's what happens to copper over time. It's the original roof of a Victorian house built in 1887. This HOA was founded in 2020. You do the math." One of the other board members, a thin man with wire-rimmed glasses, cleared his throat. "The age of your house is irrelevant to current neighborhood standards, Mr. Quinlan. We're trying to maintain a cohesive aesthetic. A cohesive aesthetic of generic suburban houses that all look the same." I shot back. "My house is an actual piece of architectural history. It belongs on the National Register of Historic Places." Patricia's expression hardened. "Your house is a decrepit eyesore that you've made worse with that ridiculous roof. You have 30 days to comply or the fines begin. This meeting is adjourned." She banged her gavel, and I stood there, stunned at the sheer audacity. Several people filed past me, some avoiding eye contact, others giving me sympathetic looks. An older gentleman with kind eyes stopped and leaned close. "Get yourself a good lawyer, son," he whispered. "Patricia has been on a power trip for months. She's forced out 3 families already with bogus violations and endless fines. Someone needs to stand up to her." I drove home fuming, my hands tight on the steering wheel. This was insane. I had poured my heart and soul into restoring this house properly, and some petty tyrant with a gavel thought she could just erase all that work with a letter. The next morning, I called Marcus again and filled him in on the meeting. He was silent for a long moment after I finished. "Henry, I need to be straight with you. Even though they are completely wrong, fighting an HOA can be expensive and time-consuming. They have funds from all their member dues, and they can drag this out in court for months or years. Some people just pay the fines or comply because it's cheaper than fighting. "I'm not taking down my roof, Marcus," I said flatly. "That's not negotiable. This roof represents hundreds of hours of work and tens of thousands of dollars. More than that, it's the right roof for this house, historically and architecturally." "Okay," Marcus said. "Then let's build our case. Get me every scrap of documentation you have. Permits, photos, communications with the Historic Preservation Office, your deed, everything. And I'm going to research this boundary expansion claim. Something smells fishy about that." I spent the next week compiling a massive file. I had been meticulous during the restoration, photographing every stage, saving every receipt, keeping copies of every permit and approval letter. The State Historic Preservation Office had been thrilled with my work, sending an official reviewer who had praised the attention to detail and authenticity. I had letters from the reviewer, from the county building inspector, from the specialized copper roofing contractor I had worked with. I also dug into the HOA's history. The Asheville Heights HOA had been created in 2020 when a developer built a small subdivision of 12 houses on what had been farmland. Over the next few years, they had somehow convinced several neighboring property owners to join voluntarily, growing to about 35 properties. My house was on the edge of this area, separated from the nearest HOA property by a vacant lot that had recently been sold. Marcus called me 10 days after the initial letter with news. "I found something interesting," he said. "The HOA did file paperwork claiming to expand their boundaries, and your property was listed in that filing. But here's the thing, there's a requirement for notification and an opportunity to opt out or contest the inclusion. Did you receive any certified mail, any legal notices, anything about this expansion?" "Nothing," I said. "The first I heard about being in the HOA was the letter about my roof." That's what I thought. I checked with the county clerk's office, and while they have a record of the HOA filing the expansion paperwork, there's no proof of proper notification to affected property owners. That's a huge problem for them. You can't just claim someone's property is now subject to your private covenants without proper legal notice. "So what's our next move?" I asked. "I'm going to send them a formal response on your behalf, denying their jurisdiction and demanding proof of proper notification regarding any alleged boundary expansion. I'm also going to include all your documentation about the historic nature of your roof and the fact that it predates their HOA by over a century. If they want to push this, they'll have to take you to court, and I don't think their case will survive even a preliminary hearing." I felt a weight lift slightly off my shoulders. "Thanks, Marcus. Send me the bill for your time." "I'm actually thinking about doing this pro bono," he said. "I've been hearing things about this particular HOA and I don't like what I'm hearing. Someone needs to push back against this kind of overreach, and you've got a righteous case." Marcus sent his letter, and for about a week, things were quiet. I went to work, came home, and tried not to obsess about the situation. My house looked beautiful, the copper roof gleaming in the afternoon sun with its distinctive green patina. Neighbors who weren't part of the HOA regularly complimented me on the restoration. Then day 31 arrived, and with it came another certified letter. This one informed me that I was now being fined $500 per day for non-compliance with HOA regulations, and that the HOA was placing a lien against my property for the accumulating fines. I called Marcus immediately, my hands shaking with anger. "They actually did it," I said. "They're fining me and threatening a lien. Forward me the letter right now." Marcus said, his voice tight. "This is going to court. They can't enforce fines or place liens on a property that isn't legally part of their HOA. I'm going to file an emergency motion to have their lien removed and a declaratory judgment that your property is not subject to their jurisdiction." Things moved quickly after that. Marcus filed our papers with the Buncombe County Superior Court. The HOA, apparently surprised that I was actually fighting back, hired their own attorney, a guy named Roger Stedman who had a reputation for defending HOAs in these kinds of disputes. The preliminary hearing was scheduled for 3 weeks out, before Judge Thomas Brennan. Marcus warned me that some judges were sympathetic to HOAs and their desire to maintain neighborhood standards, while others took a harder line on property rights. We didn't know which way Judge Brennan would lean. In the meantime, the fines kept accumulating on paper. The HOA sent me weekly updates, each letter more threatening than the last. I was now supposedly on the hook for over $10,000 in fines, with interest accruing. Patricia Carmichael sent a personal letter suggesting that if I would just be reasonable and replace the roof with appropriate materials, they would waive the fines and we could all move on. I wrote back a single sentence: "See you in court." The harassment escalated. Someone filed a complaint with the city building inspector, claiming my roof was unsafe and improperly permitted. The inspector, a guy named Dave Chen who I had worked with during the restoration, showed up looking annoyed. "Henry, I've got to respond to every complaint we receive," he said apologetically, walking around my house with his clipboard. "But I inspected this work when you did it. I know it's solid." "Patricia Carmichael filed this, didn't she?" I said. Dave didn't answer directly, but his expression told me everything. He took some photos, checked his old files on his tablet, and signed off on the inspection. "Roof is properly permitted, professionally installed, and meets all applicable building codes," he said officially. "In fact, it's probably the best roof in this neighborhood. Those architectural shingles they're pushing barely last 20 years. Your copper roof will outlast your grandchildren." "Can you put that in writing?" I asked. "Already done," Dave said, handing me a copy of his inspection report. "Good luck with your HOA problem. I've seen too many of these associations turn into little dictatorships." I added Dave's report to our growing file. Marcus was building a case that he said would be bulletproof. Besides the question of jurisdiction, which he considered our winning argument, he wanted to show that even if somehow the HOA did have authority over my property, which they didn't, my roof would be protected under historic preservation laws. I did some research of my own and discovered something interesting. North Carolina has a law protecting historic properties from overly restrictive covenants and regulations. The law recognizes that historic preservation is in the public interest and takes precedence over private aesthetic preferences. My house, with its documented 1887 construction date and approved restoration, should qualify for protection even if I was somehow subject to the HOA. I also learned that the North Carolina Historic Preservation Office could designate individual properties as historic landmarks, which would provide even stronger protection. I reached out to the reviewer who had signed off on my roof restoration, a woman named Dr. Sarah Vandenberg, and asked about the process. "Henry, your house absolutely qualifies," she said over the phone. "The integrity of the restoration you've done is exceptional. We would be happy to initiate the landmark designation process, but I should warn you, it typically takes 6 to 12 months. "Will it help with my HOA problem?" I asked. "It should," she said carefully. "But the courts move slowly and HOAs can be remarkably stubborn. Let me make some calls. Maybe we can expedite things given the circumstances." True to her word, Dr. Vandenberg worked some magic within the State Preservation Office. Within 2 weeks, I received a preliminary determination letter stating that the Quinlan house, as they officially designated it, was eligible for state historic landmark status, and that the property was considered to be under the protection of state historic preservation statutes, pending final designation. Marcus was thrilled when I sent him the letter. "This is gold, Henry," he said. "Absolute gold. We're not just arguing property rights anymore. We're arguing that the state of North Carolina has a vested interest in protecting your property's historic character, and some suburban HOA doesn't get to override that." The week before our hearing, I got a call from an unknown number. I almost didn't answer, but something made me pick up. "Mr. Quinlan, this is Jennifer Morrison. I'm a reporter with the Asheville Citizen-Times. I heard about your dispute with the Asheville Heights HOA, and I'm wondering if you'd be willing to talk about it." I hesitated. "How did you hear about this?" "Court filings are public record," she said. "And I've been following stories about HOA overreach in the area. Yours caught my attention because of the historic preservation angle. A Victorian house with an original copper roof being threatened by an HOA formed just a few years ago. That's a compelling story." We talked for over an hour. Jennifer was thorough and knowledgeable, asking smart questions about the restoration process, the legal issues, and the broader implications for historic properties in neighborhoods with HOAs. She said she wanted to run the story before the hearing. "Public opinion can sometimes influence these outcomes," she said. "Not directly, but judges are human. They read the news, and if the community is outraged by HOA overreach, that matters." The article ran 3 days before the hearing, complete with beautiful photos of my house and its distinctive copper roof. Jennifer had done her homework, interviewing not just me but also Dr. Vandenberg from the Historic Preservation Office, Dave Chen, the building inspector, and several neighbors both in and outside the HOA who supported my position. She also got a quote from Patricia Carmichael that made my jaw drop. "Mr. Quinlan's personal aesthetic preferences don't override the collective good of the neighborhood," Patricia was quoted as saying. "His insistence on this garish metal roof is selfish and detrimental to everyone's property values. Rules exist for a reason, and no one is above them." The response was swift and overwhelmingly in my favor. The newspaper's website comments section lit up with people defending historic preservation and criticizing the HOA. Local preservation groups shared the article on social media. The Asheville Area Home Builders Association issued a statement supporting proper historic restoration. Even the mayor made a comment to another reporter about the importance of protecting Asheville's architectural heritage. Patricia apparently didn't like the attention. She called me directly 2 days before the hearing, her voice tight with barely controlled anger. "You've turned this into a media circus," she snapped. "This should have been a simple matter of following rules." "Your rules don't apply to my property," I said calmly. "They never did. Judge Brennan isn't going to care about your newspaper articles or your fancy letters from the state," she said. "The law is on our side. You're in our boundaries. You're subject to our covenants." "Then I guess we'll let the judge decide," I said and hung up. Marcus had warned me not to engage with Patricia directly, but I was past caring about being diplomatic. She had tried to bully me into destroying my careful restoration work, and I was done being polite about it. The morning of the hearing, I put on my best suit and met Marcus at the courthouse. It was a beautiful spring day in Asheville, the kind of morning that makes you remember why you love living in the mountains. The courthouse was an imposing brick building downtown, built in the 1920s with its own sense of historic dignity. We went through security and found our courtroom on the third floor. Patricia was already there with Roger Stedman, her attorney, and 2 other HOA board members. She glared at me as I walked in but didn't say anything. Judge Brennan turned out to be a silver-haired man in his 60s with a no-nonsense demeanor. He called our case promptly at 9:30 and gestured for both attorneys to approach. "Gentlemen, I've reviewed the filings from both sides," Judge Brennan said. "Mr. Webb, your client contends that his property is not and has never been subject to the Asheville Heights HOA covenants. Mr. Stedman, your client contends that Mr. Quinlan's property was properly incorporated into the HOA boundaries through an expansion process, and that he is therefore subject to their architectural standards. Is that an accurate summary?" Both attorneys agreed that it was. "Then let's start with the threshold question," Judge Brennan said. "Mr. Stedman, can you prove that Mr. Quinlan's property is legally subject to your client's HOA covenants?" Roger Stedman stood and began his argument. He presented the HOA's boundary expansion filing from the previous year, showing that my property had been included in the expanded boundaries. He argued that the expansion was properly filed with the county and that I had been given constructive notice through the public filing. Judge Brennan listened, occasionally making notes. When Stedman finished, the judge turned to Marcus. "Mr. Webb, your response." Marcus stood and methodically dismantled their argument. He showed that I had never signed any agreement to join the HOA, that my deed contained no reference to any HOA covenants, and most damning, that there was no evidence I had received actual notice of the alleged boundary expansion. "Your Honor, the HOA claims that filing paperwork with the county constitutes adequate notice," Marcus said. "But North Carolina law is clear that property owners must receive actual notice when they're being subjected to new covenants or restrictions. A filing in the county clerk's office that no one tells you about isn't notice. It's a secret." Judge Brennan leaned forward. "Mr. Stedman, did your client send any certified mail or other direct notice to Mr. Quinlan about this boundary expansion?" Stedman shuffled through his papers, and I could see Patricia whispering urgently to him. Finally, he straightened up. "Your Honor, the HOA believed that the public filing was sufficient notice under the circumstances." "That's not what I asked," Judge Brennan said, his voice sharp. "Did you send direct notice to Mr. Quinlan? Yes or no?" "Not certified mail, no," Stedman admitted. "But there was a general announcement in the neighborhood newsletter." "Does Mr. Quinlan receive this newsletter?" the judge asked. "It's available to all residents in the area," Stedman said weakly. Marcus jumped in. "Your Honor, my client has never received this newsletter, never subscribed to it, and never even knew it existed until this lawsuit. He cannot be bound by covenants he never agreed to on the basis of notice he never received, by an organization he never joined." Judge Brennan nodded slowly and made more notes. Then he looked up. "Even if we assume, purely for the sake of argument, that Mr. Quinlan's property is somehow subject to the HOA covenants, let's talk about this roof. Mr. Stedman, your client is demanding that a copper roof installed in 1887 be removed and replaced with modern shingles. Do I have that right?" "Your Honor, the roof was recently restored," Stedman said. "This isn't about the original 1887 installation, but rather about work Mr. Quinlan performed in 2023 and 2024. Work that consisted of restoring the original 1887 roof," Judge Brennan said. It wasn't a question. Marcus handed the judge a thick binder. "Your Honor, this contains complete documentation of Mr. Quinlan's restoration work, including approval letters from the North Carolina Historic Preservation Office, permits from the county building inspector, and a preliminary determination that the property qualifies for state historic landmark status. Judge Brennan spent several minutes flipping through the binder, his expression unreadable. Patricia was shifting uncomfortably in her seat, and Stedman was whispering to her, probably telling her this wasn't going well. Finally, Judge Brennan closed the binder and looked at Patricia directly. "Mrs. Carmichael, you're the HOA president, correct?" Patricia stood up nervously. "Yes, Your Honor." "Are you familiar with North Carolina's historic preservation statutes?" Well, I know they exist, but our architectural standards." "Let me make this very simple," Judge Brennan interrupted. "The state of North Carolina has determined that Mr. Quinlan's property has historic significance, and that his restoration work preserves important architectural heritage. The state has given preliminary approval for landmark designation. You are asking this court to force Mr. Quinlan to destroy historically significant and state-approved restoration work so that his house will match your neighborhood aesthetic. Is that correct?" "Your Honor, it's about property values and neighborhood cohesion," Patricia said, her voice taking on that condescending tone I had heard at the HOA meeting. "Mrs. Carmichael, I've been practicing law in North Carolina for 42 years, Judge Brennan said, and there was steel in his voice now. "I've seen a lot of HOA disputes. I've seen HOAs serve legitimate purposes, maintaining common areas and protecting property values. But I've also seen HOAs become vehicles for petty tyrants to impose their personal preferences on their neighbors." Patricia's face went red. "Your Honor, I object to that characterization." "You can object all you want, but you're not a party to this proceeding. Your HOA is," Judge Brennan said. "And here's what troubles me. We have an architect who bought a historic Victorian house and spent considerable time and money restoring it properly. He worked with the State Historic Preservation Office. He pulled proper permits. He did everything right. And your HOA, formed less than 5 years ago, is trying to force him to destroy his restoration work because you don't like how it looks." Judge Brennan paused and looked at Stedman. "Counselor, even if I were to find that Mr. Quinlan's property is subject to your client's covenants, which I'm not inclined to do given the notice issues, I would still rule against you on the merits. North Carolina law explicitly protects historic preservation efforts from overly restrictive covenants. Your client's aesthetic preferences do not override the state's interest in preserving architectural heritage." I felt a wave of relief wash over me. Marcus squeezed my shoulder. Judge Brennan continued, "Furthermore, I'm deeply troubled by the HOA's attempt to place a lien on Mr. Quinlan's property for fines related to alleged violations of covenants that I'm not convinced even apply to him. That strikes me as potentially fraudulent." Patricia stood up again. "Your Honor, we have every right to enforce our covenants." "Sit down, Mrs. Carmichael," Judge Brennan said sharply. "You're not helping your case. Mr. Stedman, does your client understand that placing a fraudulent lien on someone's property can expose them to significant legal liability?" Stedman looked uncomfortable. "Your Honor, my client believed they were acting within their rights." "Believing you have rights you don't actually have is not a defense," Judge Brennan said. He turned back to his notes and wrote for a solid minute while we all waited in tense silence. Finally, he looked up and addressed both attorneys. "Here's my ruling. First, I find that Mr. Quinlan's property was never properly incorporated into the Asheville Heights HOA boundaries. The alleged expansion process failed to provide adequate notice to affected property owners, and therefore that expansion is void as it relates to Mr. Quinlan's property. Mr. Quinlan is not subject to the HOA's covenants, never has been, and cannot be made subject to them without his explicit agreement. Marcus was grinning. I felt light-headed with relief. Second, Judge Brennan continued, even if the HOA's covenants did apply to Mr. Quinlan's property, which they do not, those covenants would be unenforceable as applied to his roof restoration. The work was properly permitted, approved by the State Historic Preservation Office, and is protected under North Carolina's historic preservation statutes. Patricia looked like she wanted to argue, but Stedman put a hand on her arm to stop her. Third, the HOA's attempt to fine Mr. Quinlan and place a lien on his property was improper and must be immediately rescinded. All fines are voided, and the lien must be removed from Mr. Quinlan's property within 7 business days. Judge Brennan paused and his expression hardened. Finally, I want to address something that concerns me greatly. Mrs. Carmichael, your HOA's actions in this matter have been heavy-handed, poorly researched, and legally questionable. You attempted to impose your will on a property owner who was not subject to your authority. You filed a lien without proper legal basis, and even after being presented with clear evidence about the historic nature of Mr. Quinlan's property, you persisted in your demands. Patricia's face was now bright red, and she looked like she wanted to disappear into the floor. I'm ordering your HOA to pay Mr. Quinlan's reasonable attorney fees in defending this action, Judge Brennan said. Mr. Webb, submit your fee petition within 14 days. I'm also putting your HOA on notice, Mrs. Carmichael, that any further harassment of Mr. Quinlan on this matter could result in sanctions, including monetary penalties against the HOA board members personally. Do you understand? Yes, Your Honor, Patricia said quietly, her earlier arrogance completely deflated. Good. This hearing is concluded. My written order will be filed by end of business today. Judge Brennan stood, and we all stood with him. He left the courtroom, and I turned to Marcus, unable to keep the smile off my face. We won, I said simply. We destroyed them, Marcus corrected. That was one of the most decisive rulings I've seen in an HOA case. Judge Brennan basically called them bullies from the bench. Patricia and her board members fled the courtroom without making eye contact. Stedman lingered for a moment and approached Marcus. Your client fought the good fight, he said professionally. I'll make sure the lien is removed by the end of the week. 7 business days as ordered, Marcus said firmly, and we'll be filing for attorney fees. Your client put us through a lot of unnecessary litigation. After Stedman left, Marcus and I stood in the hallway outside the courtroom, and I felt the tension of the past 2 months finally draining away. What happens now? I asked. Now we make sure they comply with the judge's order, Marcus said. I'll monitor the lien removal and file my fee petition. You should also follow up with the Historic Preservation Office about finalizing your landmark designation. That'll give you permanent protection against this kind of thing. And if Patricia tries something else, then she'll be in contempt of court, and Judge Brennan will come down on her even harder, Marcus said. Trust me, Henry, she's not going to mess with you again. She just got publicly humiliated by a judge who has a reputation for not tolerating nonsense. Word is going to spread fast in the HOA community. Jennifer Morrison called me that afternoon, having already heard about the ruling through her courthouse sources. We did a follow-up interview, and her article ran the next day with the headline "Judge Rules Against HOA in Historic Roof Dispute, Calls Out Heavy-Handed Tactics." The article was even more widely read than the first one. The online comments section was brutal toward Patricia and the HOA. Several people who lived in other HOAs talked about similar experiences with overreach and abuse of power. A few state legislators even weighed in, with one promising to look into strengthening protections for historic properties against HOA restrictions. The lien was removed from my property in 5 business days, faster than the judge had ordered. Marcus filed his fee petition seeking $18,000 for his work on the case. The HOA's attorney tried to negotiate it down, but Marcus held firm and eventually they paid the full amount. The real consequences for Patricia and the HOA came about 3 weeks after the hearing. I got a call from the older gentleman who had warned me at that first HOA meeting. His name was George Patterson, and he had been fighting his own battle with the HOA over solar panels on his roof. "Henry, thought you'd want to know," George said cheerfully. "There was an emergency HOA meeting last night. Patricia was voted out as president. Actually, she was voted off the board entirely. About 2/3 of the HOA members showed up, and they were angry about the legal fees and the bad publicity." "Really?" I said, surprised at how quickly things had turned. "Really?" "There's also talk about dissolving the whole HOA or at least dramatically scaling back what it controls. A lot of people joined thinking it would just handle basic maintenance of common areas, but Patricia turned it into her personal fiefdom. Your lawsuit opened people's eyes to what was happening." I felt a surge of satisfaction. Patricia had tried to bully me into destroying my restoration work, and instead, she had lost her little kingdom. The story didn't end there, though. About a month after the court ruling, I was contacted by the North Carolina Historic Preservation Office. Dr. Vandenberg called with news. "Henry, your landmark designation has been fast-tracked and approved," she said. "The Quinlan house is now an official North Carolina historic landmark. Congratulations." "That's incredible," I said. "Thank you for all your help with this." "There's more," she said. "Your case has sparked interest at the state level. The legislature is considering a bill that would strengthen protections for historic properties against HOA restrictions. They're calling it the Quinlan House Protection Act, informally. You might get called to testify if it moves forward." I did end up testifying before a state legislative committee about the importance of protecting historic properties. The bill passed 6 months later, creating a clear statutory framework that prevents HOAs from interfering with properly documented historic preservation work. It was surreal seeing my case become the basis for state law. Life slowly returned to normal. I continued my work as a restoration architect, and my own house became something of a showcase. Other homeowners with historic properties reached out to me for advice on preservation and dealing with their own HOA issues. I helped several people successfully fight back against overly restrictive covenants. I also completed the historic landmark designation process for my property, which came with a beautiful bronze plaque that I mounted next to my front door. It reads, "The Quinlan House, circa 1887, North Carolina Historic Landmark." Every time I see it, I feel a sense of pride and vindication. Patricia never bothered me again. I saw her occasionally around town, usually at the grocery store or coffee shop. She would quickly look away whenever our eyes met. According to neighborhood gossip, she moved out of the HOA neighborhood about 8 months after the court ruling, selling her house and relocating to a different part of Asheville. The HOA itself went through significant reforms. The new board, led by George Patterson, rewrote their covenants to focus on actual quality of life issues like maintaining common areas and enforcing reasonable noise restrictions. They dropped most of the arbitrary aesthetic requirements that Patricia had loved to enforce. The neighborhood became noticeably friendlier and less tense. Marcus and I became good friends through the whole ordeal. He later told me that my case was one of his favorites in 20 years of practicing law. "It had everything," he said over beers one evening. "Clear good guy, clear bad guy, beautiful historic property, absurd overreach, and a judge who wasn't afraid to call it out. Plus, we actually made law that will help other people. That doesn't happen often. The most gratifying moment came about a year after the court ruling. I was giving a tour of my house to a group from the local historical society when a young couple approached me afterward. "Mr. Quinlan, we're thinking about buying a Victorian house in another neighborhood, but there's an HOA," the woman said. "Your case gave us hope that we could restore it properly without the HOA interfering. Would you be willing to give us some advice?" I spent an hour talking with them about documentation, working with the Historic Preservation Office, and understanding their property rights. They bought the house and did a beautiful restoration, successfully fighting off their own HOA's objections using the precedent from my case and the new state law. Standing on my porch on a cool autumn evening 2 years after that initial threatening letter arrived, I looked up at my copper roof gleaming in the sunset. The patina had deepened slightly, the green taking on richer tones. It was exactly how it should look, exactly how it had looked in 1887 when the house was new. I thought about how close I had come to giving in, to just complying with Patricia's demands to avoid the hassle. If I had, this beautiful piece of architectural history would have been covered up with generic asphalt shingles, and the HOA would have moved on to bully the next person who didn't fit their narrow vision of acceptable. But I had fought back, and in doing so, I had not only protected my own property, but had helped establish legal protections that would shield other historic properties across North Carolina. The case had become a cautionary tale about HOA overreach and a success story about standing up for what's right, even when it's difficult. My phone rang, breaking my reflection. It was a number I didn't recognize, but I answered anyway. "Mr. Quinlan, this is Robert Hayes. I'm a homeowner in Charlotte with a 1920s craftsman bungalow. My HOA is trying to make me remove my original wood siding and replace it with vinyl. I read about your case, and I was hoping you might be able to point me toward resources or legal help." I smiled and settled into my porch chair. "Robert, I'd be happy to help. Let me start by telling you about a really good attorney named Marcus Webb, and then I'll walk you through what documentation you're going to need." As I talked Robert through the process, explaining how to work with his state historic preservation office and what arguments had worked in my case, I realized that the battle with Patricia and the HOA had become something bigger than just my roof. It had become a blueprint for other people fighting similar battles, a reminder that sometimes the little guy with a righteous cause can beat the bureaucracy. The copper roof above me had survived 135 years of weather, neglect, and changing architectural fashions. It had survived my restoration process, and it had survived Patricia Carmichael's attempt to erase it. It would be there long after all of us were gone, a testament to the craftsmen who first installed it and the importance of preserving our architectural heritage. And every time someone drove by and stopped to admire the beautiful Victorian house with the distinctive green copper roof, every time another homeowner reached out for help fighting their own HOA battle, every time someone cited the Quinlan House Protection Act, I knew that standing up to that certified letter on that Tuesday morning had been absolutely the right decision. The house stood as it should, historic and protected, a small victory for preservation and property rights in a world that too often prioritizes conformity over character. And I stood on its porch, the owner not just of a beautiful piece of architecture, but of a story that mattered, a case that made a difference, and a roof that would outlast all the petty disputes and power-hungry HOA presidents the world could throw at it. Judge Brennan had laughed at Patricia's attempt to override history and law with her HOA covenants. That laugh, That moment of judicial incredulity at the sheer audacity of trying to erase 135 years of architectural history for the sake of neighborhood conformity had echoed far beyond that courtroom. It had become part of the story, the moment when absurdity met authority and lost decisively. As the sun finished setting and the first stars appeared above the mountains, I went inside my historic house, secure in the knowledge that it was protected, preserved, and would stand for generations to come, copper roof and all.